Before we even get into the courtroom exchange, understand what you're about to watch. This is not a simple yes or no hearing. This is a probation revocation proceeding, and those carry real stakes. We're talking about whether a person who was previously given a chance by the court, often instead of jail time, has allegedly violated the conditions of that agreement. And once that question is on the table, everything becomes laser-focused on compliance, documentation, and credibility. In this case, the defendant, Cynthia Deanna, is brought before the court regarding a motion to revoke her deferred adjudication. That basically means the state is saying, you were given a chance, and now we believe you didn't follow the rules of that chance. But here's where things immediately get complicated. Confusion starts right at the most basic level, understanding what the document even says. And in a courtroom, that's not a small issue. If a defendant doesn't understand the allegations, can they meaningfully respond to them? What makes this even more intense is the judge's approach. Direct, structured, and procedural. There's no room for storytelling yet. No explanations. Just understanding first, answers second. But the defendant repeatedly says she doesn't understand, which raises a serious procedural tension. Is this confusion, miscommunication with counsel, or something deeper like competency concerns? And then it escalates. Allegations begin stacking. Alcohol consumption, failure to report, driving without a license, ignition interlock violations. Each one is a separate condition of probation, and each one carries potential consequences. So the big question heading into this hearing is simple but powerful. Was this a pattern of violations, or a misunderstanding being interpreted as non-compliance? Let's go inside the courtroom.
And are you Miss Cynthia Deanna? Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it? Oh, you don't understand this?
No.
Okay. You don't understand that you're on probation?
No, I do understand that I'm on probation, but if I may say that with...
No. Let me just tell you.
Please.
This is a document.
Yes, ma'am.
This is a document that's a motion to revoke your deferred adjudication. In this document, it states what they're complaining about. So do you understand what they're complaining about?
I don't.
No, my question is,
No.
Do you understand what's in this document?
I don't understand.
Okay.
Judge, may I ask an unconventional favor question? I just spoke with my client's daughter, who I think could be beneficial moral support for this and might have some insight as is she someone that you trust?
My daughter.
This moment right here is where the tone of the entire hearing starts to shift. The judge is doing something very specific, trying to lock in whether the defendant understands the motion to revoke probation. And legally, that's essential. If someone doesn't understand the charges or the motion, the court can't just move forward blindly. That's where competency concerns even start to enter the conversation. But what we're seeing is repeated uncertainty. I don't understand. Then a partial yes, then back to no. And that inconsistency is exactly what makes the judge pause and consider whether a formal competency evaluation might be necessary. That's not a punishment, it's a safeguard. Courts cannot proceed if a defendant cannot meaningfully participate in their defense. What's also striking here is the attorney's attempt to clarify and support, while the judge keeps narrowing the focus. Not explanations, not emotions, just comprehension of the document. This is procedural law at its most rigid form. And here's the real question for viewers. When someone says both, yes, I understand, and no, I don't, how does a court fairly interpret that in real time? Because in a probation revocation case, misunderstanding the document doesn't stop the case, but it can absolutely change how the court proceeds next.
Yes, sir.
How old are you?
I'm 48.
All right, so here's the thing.
I lost my child.
No. Here's my thing. No. My only question for you right now, this is a process. So to get to the process where you want to tell me what's going on in your life, the first thing I need to know is whether or not you understand this motion to revoke. It doesn't matter if you're saying, well, you know what? Let me give you a reason for why this isn't true. We're not at that point yet. Okay. Where we are is this document that says the state wants to revoke your probation. Has that been explained to you by your attorney?
Yes.
Do you understand it?
Yes,
No, I mean, if you don't understand it, just tell me. You don't?
I don't.
All right. So if you think she needs to be evaluated for competency, you can do that. This will be reset.
No, I don't think that, yes, I do know what you're saying. Yes,
So do you understand this document?
yes,
All right. Are you the same Cynthia J. Deanna who was placed on deferred adjudication in 2025 CR 001146 for the offense of assault causing bodily injury on June 2nd, 2025 for a period of 1 year and extended for 1 year? Is that you?
for 1 year, yes.
Now the courtroom shifts from, do you understand? To, how do you plead? And this is where the legal pressure intensifies significantly. The state begins laying out specific violations tied to probation conditions, and each one is very precise. Dates, locations, and alleged conduct. First up, consuming alcohol in April 2026. That might sound simple, but in probation terms, even one violation can trigger revocation proceedings. Then we move to failure to report to a supervision officer, again, a core condition in nearly every probation order. These reporting requirements are not optional. They are foundational to the entire supervision system. What's important here is how the court structures this. Each violation is read individually, and the defendant is required to respond true or not true. That's deliberate. It creates a clear record for later evidentiary hearings. And as each allegation is read, the defendant consistently denies them. That sets the stage for what comes next, a contested hearing. But here's the bigger legal takeaway. Probation isn't just about avoiding jail. It's a contract with strict conditions. The state is now claiming that contract was broken multiple times. So the question becomes, are these alleged violations isolated misunderstandings, or a pattern the state can prove in court?
State, proceed.
Judge, we proceeding on violation condition number 2, specifically that on or about the 8th day of April 2026 in Berry County, Texas, the defendant Cynthia J. Deanna did then and there consume alcoholic beverages in violation condition number 2.
How do you plead to
Wait.
that? True or not true?
What day was this? What are we talking about?
It's the document that we read earlier.
Which condition? You're talking about number 2. They are saying that on April 8th, 2026, you drank, they're using the word consume, but they're saying you drank alcohol. Did you do that?
No,
All right, so she's pleading not true to violation of condition number 2. What's next?
Judge, we'll also be proceeding on violation condition number 4, specifically that in Berry County, Texas, the defendant Cynthia J. Deanna did then and there fail to report to the supervision
Slow down.
officer. My apologies, Judge.
That's okay.
As directed for the months of April 2026 in violation condition number 4.
So number 4, they're saying you didn't report in April 2026. Yes or no?
that is
Not
not
excuse. Yes or no? True or not true?
true.
All right.
Judge will also be proceeding on a violation of condition number 13, specifically that on or about the 18th day of May 2026 in Berry County, Texas, the defendant Cynthia J. Deanna did then and there operate a motor vehicle without a valid driver's license in violation of condition number 13.
True or not true?
Not true.
Judge will also be proceeding on another violation, condition number 13, specifically that on or about the 26th day of May 2026 in Berry County, Texas, the defendant Cynthia J. Deanna did then and there operate a motor vehicle without a valid Texas driver's license in violation of condition number 13.
Not true.
Yes. 29.
Judge will be proceeding on violation case number 29, specifically that on or about the 18th day of May 2026 in Berry County, Texas, the defendant Cynthia J. Deanna did then and there operate or control a motor vehicle not equipped with an approved ignition interlock device as instructed by the court in violation of condition number 29.
True or not true?
Not true.
At this point, the courtroom has reached a procedural crossroads. Every allegation presented by the state has been met with a denial. Not true across the board. That changes everything because now nothing is agreed upon and everything must be proven. The judge responds exactly as the law requires. This will proceed to a contested hearing. That means both sides will return, evidence will be presented, and witnesses may be called. This is where probation revocation cases are actually decided, not in today's hearing, but in the evidentiary battle that follows. What stands out here is the judge's firm control of procedure. When the defendant attempts to speak further, the court declines. That's not dismissiveness, it's structure. At this stage, courts prioritize scheduling, clarity of claims, and ensuring both sides are prepared for trial-like proceedings. There's also a subtle but important moment involving counsel and representation concerns. That signals possible tension between the defendant and legal strategy, which could become relevant later, but it does not change today's procedural outcome. So now everything pauses, but nothing is resolved. And the real tension builds. When every allegation is denied, the burden shifts entirely to the state to prove each violation with evidence.
All right, thank you. We're going to set this for a contested hearing. You're all going to be back the second week in in July for a contested hearing on this matter.
May I just say something?
No.
Please, Ms. Boyd.
No, thank you.
Ms. Boyd.
All right, we're going to bring you back on the second week in July, and at that time, we'll have a hearing, okay? And then the state will have to present evidence to substantiate the allegations that they have in the motion. If they are not able to prove it up, then the court will find it not true. If they do prove it up, then the court will find it true.
Judge, for the record, if I may, my client is not satisfied with my representation and would like to file complaints about me with whatever.
She's only been on it for 2 days, but she doesn't, I asked her to hear me out. She didn't want to hear any of the things that I have.
All right, so this is what I can say. I've heard you in the box with your attorney all morning. This is coming back for a contested hearing, and it's coming back for a contested hearing the week. I'm sorry, when?
July 6th.
No, let's give them,
I just wanted her to hear me out, so, you know. Asked you to hear me out.
I am hearing you out.
tell Norma it's going to have to be the July 9th, so defense counsel will have enough time. So we'll see you back on July 9th for a contested hearing. My daughter's number. Can you give it to me?
Yes, I can.
Here's where this case stands in clear legal terms. Cynthia Deanna is facing a motion to revoke deferred adjudication probation based on multiple alleged violations, ranging from alcohol consumption to failure to report, driving-related restrictions, and ignition interlock conditions. At this stage, nothing has been proven in court. Every allegation has been denied, which means the case is now headed for a contested evidentiary hearing. The judge's ruling today was procedural, not final. No guilt was determined. Instead, the court set the matter for a future hearing where the state must present evidence to substantiate each claim. If they fail to meet that burden, the allegations will be found not true. If they succeed, probation could be revoked entirely, leading to significantly harsher consequences. What makes this case important is how clearly it shows the structure of probation law. It's not just about one mistake. It's about compliance over time, and how courts evaluate whether trust placed in a defendant has been upheld or broken. So now the real battle hasn't happened yet. It's coming in July. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.